recorded. We will upload the full footage of the court case after this is done. Um, so you
Can you
know,
hear Dear Ev in the background from the live stream?
um, let me turn up the volume. Could Dear speak?
Dear Ev, could you say something? Can you hear him say what?
No, I can't hear anything. Um,
Could you speak into the live stream?
yeah, nobody's getting audio on the live stream. On the uh. Oh wait. Yeah, nobody's getting.
Raz, can you hear him speak?
No, I can't hear anything on your stream.
Okay.
For the people who have just joined, we are currently waiting for uh, audio from the court, from the Google Meet. While we wait, yeah. While we wait for audio, Super Whoops has said, "Hello everyone, I am the court stenographer. I will be typing any changes to proceedings through here, orders, etc. Obviously, I can't type out the full arguments here, but I will transcribe everything at the end." We are still waiting on getting the audio from the Google Meet.
I'm doing Twitch because the audio path is not working directly from the stream. So I'm going to
Okay.
stream the Twitch itself.
Okay.
So that way there's audio capture.
Okay.
So give me 1 second and then we can begin.
The Twitch link is we don't have the Twitch link, but the live stream link that we're doing is available in the news channel. If you want to watch the RazNews live stream.
Why can't I get the full?
Is everything okay?
I'm trying to get my full screen and it's not. It's like zoomed in on OBS. Let me just restart OBS and see if that works. Nope. Oh, there it goes. Why is it? All right. I don't have enough time to figure this out. If I had more time, I could have figured this out. Then I gotta start streaming from Twitch.
It is very packed. Oh boy.
Oh. I just heard somebody. We can hear it. We can hear it. We can hear it.
Gonna be a joke.
We can hear the audio.
All right.
You're the bailiff.
Audio
Is there a bailiff?
audio is working. I am going to be muting myself. I am gonna jump out into the jury box. Audio is working. I'm just gonna go into events. Going to be muting myself. I am gonna jump out into the jury box. Audio is working. I am going to be muting myself. Have a good trial, everybody, and enjoy yourselves.
Thank you.
All right,
Joe, I just wanna
so
say the echo is
all right, so is everyone hearing properly?
Yeah, we can hear you.
I can hear you. Yes.
All right, so court is now in session. According to the timeline posted within the case thread, we shall now have um 10 minutes for the objection hearings within the two objections posted on Friday by ToadKing, the plaintiff in this case. Plaintiff may provide their statement on the objections, and they shall have 10 minutes to do so.
The plaintiff has nothing to state further on the objections than the objections themselves.
In that case, the defendants and their counsel may have 10 minutes to provide their statements on the objections.
I thought I already wrote it down. Should I read it out loud, or are we good
If you
on
wish,
that
you have 10 minutes to do so.
Okay, hang on.
Sorry.
Minor technical issues. Just wait. You can hear me, right?
Yep.
All right. Your Honor, while the defense concedes that the Fluff Regulation Act had yet to be passed, and thereby was technically legal for the plaintiff to throw around as they saw fit at the time, the legal status is not what is in question here. Ex post facto cannot apply here, as the defense is not prosecuting the plaintiff for these activities. This is a civil proceeding, not a criminal one. What we must discuss is instead whether or not Fluff is suspicious. While the act had yet to receive presidential assent, the discourse surrounding the substance was already widespread, and the fact that the powers that be were considering criminalizing Fluff gave the consumable a suspicious profile. This is even heard in D001, as when defendant Ye Jaren picked up the fluff that he reasonably assumed had been thrown by the plaintiff. He states in the voice chat, "Yo, I think he just gave me drugs," to defendant Wahhfff before both approached the plaintiff. The negative stigma surrounding Fluff, along with the fact the item was renamed to Eat Me, was certainly enough to be considered suspicious. This suspicious activity, along with other arguments stated in defense 2, makes the defense believe that the plaintiff's behavior reached the threshold for being considered provocative.
Yes, they're claiming
That's
that
for the
Fluff
first
is
objection.
suspicious.
Wait, actually, I
And
did the objections in reverse, I realized, but that's neither here nor there. Next, Your Honor, the plaintiff referring to the separate incident documented in D004 as something the defense references as the center of the case is a gross exaggeration. It is but a factor I considered, given how the trajectory of the projectile the plaintiff fires in D004 is going in Miss Watson 221B's direction. Given how Miss Watson's place in the earlier parts of D001 was mentioned, I found this coincidence quite intriguing. It paired nicely with the argument made in Defense 2B, but I digress. The defense has no complaints if the court finds that D004 is inadmissible, but respectfully asks that we do not strike answer 5, as other arguments for it still remain in Defense 2, even if the entirety of 2C is struck from the record. Answer 5 is still a position we intend to have, as the plaintiff handled and distributed suspicious, even if not illicit, substances, while possibly following the defendants. There we go.
so I think they're claiming some
Do any of
harassment.
the two parties have anything else to say about the objections before the court retreats into the chambers to make a decision on them?
The plaintiff has nothing further to state.
Does the defendant have anything further?
Nope. We're all good.
We shall now have 10 minutes in recess so the court can make a decision on the objections.
Right, I'm gonna get an actual legal guy up into the stage. Small Fries, would you like to give us your legal commentary on the case? Okay, is there any other lawyer? Super
Please do
Whoops?
not bring anybody up on the stage. Thank you.
Oh, okay, okay.
In the meantime, I'd just like to remind everybody that do not cause any troubles in the court. That would be met with maximum penalty under the law for contempt of court, as it would be disturbing a public court session. Thank you.
Yeah, I just wanted somebody in the stage so that somebody could maybe deliver some commentary. But you see, the thing is that I'm not actually a lawyer. So personally, I would say that ToadKing probably has a strong case here. I do feel like, if they brandished weapons towards ToadKing, I feel like that's pretty, clear cut. But the defense also has some pretty strong arguments, and so I feel like it's a very varied case here, and it could go either way. But I do feel like Toad King's argument is a little bit better. And with the objections that were said by the defense, um, I I feel like it's kind of funny to say that fluff is an inherently suspicious substance. I feel like that's pretty funny, and if I had to be honest, suspicious fluff. You know, if I was given fluff and I felt like,
Raz, this is a courtroom. Please don't give commentary.
well, that was the entire point of all this.
The court is back in session. A ruling on both objections have been reached. The court shall now explain those rulings. On the first objection, it is sustained in part and overruled in part. Uh, although fluff, although the Fluff Regulation Act, which was signed and was signed into law into the 18th of March 2026, in the case whoever is interrupting the court with a musical instrument, please refrain from doing so. It will result in contempt of court. Anyways, with the Fluffs Regulation Act being passed on the 18th of March 2026, which was 3 days after the incident, the court determines that at the time Fluff was not illicit, as the law had not been signed into its full extent. Any claim or implication that the fluff was illegal at the time will hereby be struck from the court. On the second objection, the objection is sustained. D4 will be excluded from the record. Meanwhile, answer 5 will not be struck from the record. Because the events occurred after the incident, they cannot be they cannot be used to justify or rationalize the defendant's earlier conduct. And because of that, the decision is hereby taken in its full entirety. D4 is struck, and any claims or interpretations that fluff was illegal at the time, that fluff was illicit at the time, will be struck. We shall now continue with our trial, moving into opening statements, which each side shall have 15 minutes to present.
Your Honor, do you wish for the plaintiff to approach that podium in the middle?
The plaintiff may approach the podium.
Oh, bear with me 1 second. There it is. Okay, I have a very short opening statement. Your Honor, this case is straightforward. On the 15th of March of this year, the two defendants pointed high-capacity restricted firearms at the plaintiff, a notably smaller individual, in a public place for a sustained period. They had no lawful authority to possess these firearms. The plaintiff brings 3 claims under the Criminal Code Act. First, assault. The evidence will show that each defendant deliberately pointed a weapon at the plaintiff, placing him in a position of danger. Second, disturbing the peace. The evidence will show that the defendant's conduct was targeted, coordinated, and sustained, and that it caused the plaintiff alarm and distress. Third, unauthorized firearm possession. The defendants have affirmed in their own answer that neither held a firearms license at the time of the incident. The defendants have denied that their conduct was deliberate.
I'll interrupt you really quickly. Bailiff, can you please, Kato is charged in contempt of court, and the maximum penalty for disturbing this court's procedures. You may take him away. He's charged on the maximum penalty under the Criminal Code Act. Thank you very much. Plaintiff may continue.
As I was saying, the defendants have denied that their conduct was deliberate. They have suggested the plaintiff was provocative. They have characterized the pointing of their weapons as, quote, an unavoidable visual artifact of player orientation within the game, whatever that means. The evidence will show that the defendants deliberately equipped their weapons and directed them at the plaintiff. The evidence will show that this was not accidental. Most importantly, the evidence will show that the defendants, in their own words, privately acknowledged the purpose of their conduct at the very moment it was occurring. Those words are entirely inconsistent with the defense now being advocated before this court. Each claim will be established on the balance of probabilities. That's my opening statement. Thank you very much.
I'm sorry, has the plaintiff finished their arguments on the
Yes,
opening statement?
I have, yes.
In that case, I once again ask whoever is playing instruments to please stop doing so, or they will be charged in contempt of court. Thank you very much. Defendant shall now have also 10 minutes, no, 15 minutes to do that. Defendant, you may now approach the bench and give your opening statement to the court.
Apologies, give me a moment. Some technical issues. Should take no longer than 1 minute.
No worries, no worries. On another note, if the parties may post their opening statements and everything said on the forums in a written form afterwards, that would be highly appreciated, although not necessary. Thank you.
I could definitely do that. That's fine.
Please refrain from punching each other in the galley. That causes a disturbance here in the court.
Norton antivirus is the bane of my existence. But anyway,
Give me a second. Let me just give something here. Yeah, it would be on yeah. So that is content. No. Um,
let me know when I can speak.
you may speak
Thank-
at your earliest convenience. You have 15 minutes maximum to deliver your opening statement to the court.
Right. Silence.
Whoever is summoning bosses outside, that is also a disturbance to the court, and you may refrain from doing so, else contempt of court will be authorized against you.
It would be deeply inconvenient if Norton antivirus makes it so that I have silence for 13 minutes and speech for 2.
Do
But
you may deliver your opening statement.
Oops.
Your Honor, I would like to apologize. It seems my game has crashed.
No worries on that. That's fine. Happens. Um, thank you,
Full
Bailiff.
press.
Thank you. Um, despite all the technical difficulties, this court is proceeding, and that's very nice.
Indeed.
Defendant may please tell the court when you are ready to proceed with your opening statements.
Your Honor, the plaintiff makes it sound like this case is simple and easy. Someone points a gun at someone, charge them. Pretty easy in it. It would be so easy if that was just how it went. But unfortunately, the situation is not that easy. You see, the claim that the defendants intended to cause harm or loss is disproven in the recording which I've showed. At the beginning of the interaction, neither was brandishing a weapon. It was not pointing your gun at someone and rushing them like, ah. No, they approached without weapons first, and then during the course of the interaction, weapons came out. But there are reasonable explanations for it. But first, we should handle the elephant in the room, the extended period of the gun being supposedly aimed at the plaintiff. That was a visual artifact, as the plaintiff was confused by that statement. Let me reiterate. That means it appeared like they were aiming their guns or pointing the barrel of the gun at them, but no, they were not. The thing about holding a gun in this game is that when you're holding the weapon and you face someone, unfortunately, it looks like you're aiming at them, even if you ain't. You can see even in the vid, Jaren faces his weapon at Wahhfff. Now, as for the beginning of the interaction, another technical issue.
No worries, no worries. I'll ask the public to please refrain from setting bounties on people whom are within this court, and from opening and closing trapdoors. If the defendant wishes to present the opening statements in parts on the chat, they may also do so, and I will read it out loud for the public, if that's more convenient.
I appreciate my voice being described as soothing.
Your Honor, I'd just like to raise an objection, not with anything the defendant's saying. It's the fact that Kukineko is a wither, and it is disturbing this court.
That is acknowledged. Kokoneko, you please return to a normal shape, or else you will be charged in contempt of this court. This is a last warning to anyone disturbing this court under the penalties of the law and of those books the Honorable Matthew have put for everybody. It has a warning in which it says that if you disturb this court, you will be charged with contempt of court and its maximum penalty. Thank you. You may now begin. You may now continue.
Now to address what was wait, is my mic working?
Yep, I can hear you.
Everything's functioning just fine. I'm not burning into a fireball at my PC. All right.
No, you sound pretty good.
Now, at the beginning of the incident, now I should address why I believe the beginning of this interaction isn't exactly as clean cut as the plaintiff makes it sound. At the beginning of the incident, as recorded in D001, while defendant Yajaran was fishing, he picked up a dropped item renamed Eat Me with the appearance and description of Fluff. While it is not illicit, it is certainly suspicious given its present reputation. He then promptly disposed of it into the sea and saw that the plaintiff was there behind him, along with Larry the Fisher. But I will be frank, I do not think Larry the Fisher is giving out suspicious drugs.
Objection, Your Honor. Assumes facts, not in evidence. The defendant can't state that when nothing has been provided as evidence to dispute that.
Defendant may respond.
No response, Your Honor. I'll let that one ride, to be honest.
Objection sustained in that case. Objection facts not in evidence. Defendant may continue. That is struck from this statement. Thank you.
But either way, the plaintiff, misspoke. This led to Yajaran, along with Wahhfff, to confront the plaintiff. During this interaction, the plaintiff then threw a wad of what appears to be fluff at defendant Wahhfff. This is, while it is not illegal at the time, as we've already established, it's certainly interesting and strange. And this is not and according to the audio of D001, this is not the first time the defendants and the plaintiff have seen each other. Wahhfff believes that he has seen the plaintiff prior and reasonably perceived that the plaintiff's presence, repeated and unexplained, possibly being a danger or possibly sorry, what? Oh, and now I should probably address what ToadKing mentioned in his opening statement, what the plaintiff addressed. The words that what my knucklehead defendants might have said. Uh, those were jokes made in a private VC and were not addressed at the plaintiff. Such threats, if you can call them that, they wouldn't have caused intimidation to said plaintiff. Apologies for the numerous technical issues, but now I believe I am finished.
In that case, witnesses shall now be summoned according to the timeline provided in the case session. We will now, the following witnesses are hereby summoned to the stand to be questioned by the plaintiff. First witnesses first witness listed on the complaint. Jaron, please step to the stand. Cookie Neko, please do not punch the trapdoors. Plaintiff may now begin questioning the witness.
Your Honor, I believe the witness stand is over there, where purple BG is seated.
Well, that's where our stenographer and our bailiff. But Purple BJ, if you may move to the stand where Comet and Matthew are currently. Purple, please move to where Comet and Matthew are sitting. Yeah.
Your Honor, as I am a notably smaller individual, as I stand right here, I cannot look the defendant in his face. So I request your permission to ask the questions here.
You may.
Thank you. If you will bear with me for 1 second.
Just another reminder that if any evidence needs to be displayed, you may ask our helper over there, Justice Matthew, which is helping this court run.
Yes.
And he will promptly display that.
Please, can the defense exhibit 1 be displayed as I ask questions? I will direct. That's all right. I will direct to specific parts of this evidence. Mr. Jaron, you may be seated. Thank you. If you'll just bear with me another minute. I need to get it up myself. Okay.
Just before we continue, Cookie Nickel has repeatedly disrupted this court's procedure. Bailiff, you may take them away, charge them with max contempt as they did with Kato, please. You may now continue. We may now begin.
I would like to direct this court to 20 seconds into Defense
No, I
Exhibit
think
01.
Give me a second. I have to push it up for me as well. All right. Have it on my side screen here. As a verbal contempt proof for a bailiff, I ordered that Cookie Neckle be charged in full contempt of court under the maximum penalty allowed by the Criminal Code Act. Thank you. Now, yeah, I already have it open here. We may proceed at best convenience, at our earliest convenience in this case.
Apologies, I didn't catch that. Are we continuing? Your Honor, are we continuing?
Yes, you may continue.
Lovely. Okay. Mr. Jaron, how would you like to be named?
Jaren is good.
Jaron is fine. Okay. Jaron, at 20 seconds in to Defense Exhibit 001. Oh, sorry, actually, first, this video is from your point of view, isn't it?
Yes, this is from my point of view.
Right. So 20 seconds in to this video, can you confirm that you approached the plaintiff?
Yes.
Can you confirm that you then moved a minigun from your inventory into your hotbar?
Yes.
Can you explain why you did that?
We just want to make sure we keep ourselves safe. The day before, or as we were fishing, we had gone back to our apartment and we had been jumped by a mysterious player. So I just brought it just so I'd have it ready because I'm not that good at Minecraft. I can't get stuff that quick. So I want to have it ready just in case something were to happen.
Okay. At 27 seconds, you then equip the minigun into your hotbar and maintain looking at the plaintiff. Can you confirm that?
Yes.
Can you explain why you did that?
Let me pull up the video. I guess we were just, we had been given the suspicious substance and we were worried that this might be another person who had been coming around and trying to kill or take our head. So I just wanted to be make extra sure that I had my weapon ready if something were to happen.
So you equipped your minigun, looked at the plaintiff to be ready if something were going to happen. Can you elaborate on that? What things could the plaintiff have done?
Pull out a much stronger weapon and shot us because there are multiple weapons. With the armor we were at, we could have been one shot because the minigun does not do much damage.
Are you aware of how much damage the minigun does? It's fine if you don't know.
We can experiment.
No.
Dang it.
Absolutely not. It's fine if you don't know.
No, I actually am very aware. I have experimented with Wahhfff in the past, and with the armor I have on, I would not take 20 per second, but sorry, wait, am I allowed to? Never mind, I did not read that. But no, it has. We've experimented in the past, and we know that it barely does any damage compared to other weapons.
Okay, so you've used the minigun before,
Yes.
and you have a general idea of the damage it can do.
Yes.
Have you ever used it on someone who is small?
No, but we know that it just like doesn't do any hearts of damage if you have full armor Or if you even just like have 2 things of prop, it just doesn't do. It doesn't do any hearts of damage. I mean,
I would just point you to the frame of the video at 31 seconds. Can you tell me what armor the plaintiff has?
you have 2 things of netherite, likely with protection 4, and then the crown, which we do not know the armor of that.
That's all right. Are you aware that the plaintiff only has 4 hearts?
At the time, no, but like as of seeing the evidence, yes.
So you didn't know at the time that the plaintiff had less health than you?
No.
Okay. At 42 seconds, the plaintiff stated in chat, big gun for such a little guy. How did you interpret that statement?
I think you just wanted to compliment our weapon, or I guess how big it was. You wanted to see it. I thought it was something interesting. I think you're just remarking how small you were compared to it. The irony of the situation. I don't know what I said that. What does that even?
So you thought that the statement meant that the plaintiff wanted to see your big gun?
Yes.
Okay. Now, at 47 seconds, the co-defendant, Wahhfff, actually says that, reads the plaintiff's statement out loud. Big gun for such a little guy. Can you confirm that?
I would have to watch the video real quick. Yes, he does read. Yeah.
I don't think it's necessary. Unless you feel it is necessary, in which case, if you're able to, Matthew, then please play the audio. If you can, technically, please play the audio.
How are you so small? How are you so small?
Big gun for such a little guy. Oh, he saw me holding the minigun.
Called intimidation.
Okay. Jaron, at 52 seconds, can you state what you said to Wahhfff after you had both equipped miniguns looking at the plaintiff? Can you state what was said by yourself?
At 52 seconds?
At 52 seconds, yes. Sorry, start at 50 seconds. At 50 seconds.
I said it's called intimidation.
It's called intimidation. So you equipped your minigun, the co-defendant equipped his minigun, and then you stated it's called, and then you stated to Wahhfff, it's called intimidation. Can you explain why you said that?
So I'm a Minecraft YouTuber. This is my living, and it's very important for me to make like very interesting videos. So what we will do is we will make jokes that, now I did say it was intimidation, but you did not hear that. It was not meant for you to be heard. We just wanted to say, hey, like, oh, look, ha, ha, ha.
Objection. Assumes facts, not an evidence. There is no evidence that you are a Minecraft YouTuber. This has not been presented in the case. I would ask that that be struck from the record.
Defendant may respond. Defendant, are you present in this court?
Indeed, we are.
You may respond to the objection made by ToadKing.
Mm,
Defendant?
Your Honor, actually, I'll withdraw that objection. I'll withdraw the
You-
objection. Okay.
You will withdraw the
Yeah,
objection.
I was
correct?
I withdraw.
silent. That one wasn't technical issues. I was silent because That felt
That's
a
fine.
little bit.
That's fine. I withdraw the objection.
You withdraw the objection. That's fine. You may
So,
proceed.
let's take it on face value that you are a Minecraft YouTuber, that what you said was not meant for the plaintiff, it was meant for supposed viewers. Can you explain why you wanted your viewers to know? Can you explain why? Can you explain why you wanted your viewers to know that your purpose was to intimidate the plaintiff?
I didn't want them to know it. In my videos, I will like make kind of like do like parodies of real life, and I like to point out when this is sort of a parody. And I was just pointing out, well, like this is like a parody of that.
So can I just confirm that you think equipping a minigun, pointing at someone significantly smaller than yourself, stating privately to the other person who has the minigun, it's called intimidation, this whole event, this whole circumstance is just parody? Is that what you're saying?
Yes, for a YouTube video.
Right. Can you, at 55 seconds into the video, the plaintiff stated, it's a supporter command. This was to answer your question, how are you so small? At 57 seconds, can you explain what you then stated? And I would like that audio to be played as well. At 57 seconds. Maybe start at 56 seconds.
But you support these bullets coming
How
into
about
your
you support
brain?
these bullets coming into your brain?
Right.
Slash.
Can you explain why you said that?
It is just a way that I will talk. Someone will say something, and then I will just hyper exaggerate what they're saying.
Right. I have no further questions on that matter.
The plaintiff has no further questions.
No, sorry. Apologies. Just on that matter specifically, I have a couple more questions. Sorry if I wasn't clear.
Okay, you may continue with your questions.
Sorry. Your defense states that as an armorer, you had a reasonable assumption that crafting a minigun meant that you were permitted to carry it. Is that correct?
Yes.
Were you aware of the Firearms Licensing Act when you crafted the minigun? Sorry, did you craft the minigun?
Yes, we crafted the miniguns.
Okay. Were you aware of the Firearms Licensing Act when you crafted the miniguns?
No, we were not.
Are you aware of it now?
Yes, we are aware of it now, and we have them.
And just to confirm, when you crafted the firearms, the miniguns, did either of you, did you specifically have a firearms license?
I crafted it in the wild, and I did not have a firearms license.
Crafted in the wild. Okay. Are you aware that the Firearms Licensing Act that amended the Criminal Code Act made it an offense to possess a firearm?
I am now, but at the time we did not believe it was so, due to our training in the university.
Can you explain why you crafted it in the wild?
That is because we had joined a wild militia with Dan Banan, and he just had the resources at a factory there. It was merely just because that's where the resources were.
Okay. Are you aware of what laws govern the wild?
Very vaguely. I remember going to the airport saying there are light laws or no laws. There's two different wilds, and I'm very unsure which one we were in.
That's fine. Would you have crafted the minigun in the city, in Revel, or any other town? So not in the wild. Would you have crafted the minigun?
Yes.
You would have. Okay. Have you ever committed a crime on this server?
I have been arrested.
What were you arrested for?
It was we had opened up an aquarium.
Objection, Your Honor. Relevance.
Sorry, I was gonna specify. Sorry.
There was an
Clear enough.
objection made. Plaintiff may respond, and defense may complement their objection.
I'm going to withdraw that comment. I'm going to withdraw that question and ask a more specific question. And I'm just going to ask the question: have you been arrested for any of the offences relevant to this case?
I do not believe so. I can think back.
Take your time. Just think carefully. Have you been arrested for any crimes relevant to this case?
I guess I was arrested in the wild once for possessing a firearm.
So you were arrested for unauthorized firearms possession. Is that correct?
Yes.
Okay. And no other crimes? Sorry,
maybe...
no other crimes relevant to the case?
No.
Okay. Did you have a genuine fear of the plaintiff when you approached him?
Yes.
If you had a genuine fear, why did you get so close to him?
Because we are just scared of like these long range weapons being able to get us while we're unawares. Because we had your back turned to you, it seemed reasonable to go and see this player, to see what they were doing. And because you were so small, we wanted to see possibly what items you were.
And this will be my final question. Picture you're in my shoes. So you're sat there and you see two large individuals, larger than yourselves, pointing massive weapons, significantly larger than your player. I mean, if you just look at any frame of 57 seconds, or if you look at Plaintiff Exhibit 001, you can see that these miniguns are massive.
Mm-hmm.
Put yourself in the plaintiff's shoes. How would you feel having these weapons pointed at you?
If I was in your shoes, I would at the time know that the minigun is not a powerful weapon, and know that if something were to start happening, I have an elytra, and I will just firework rocket away, which the two other people do not have.
Okay, I have no further questions.
The plaintiff has no further questions.
For this witness.
In that case, does the plaintiff we shall begin the second witness listed on the complaint, which is Wahhfff. Wahhfff, are you present?
Yes, I am present.
Please go to the stand. I will begin the time for 10 minutes as per the timing rules. As soon as the plaintiff makes the first question.
Okay, if you bear with me for one moment.
Once again, after the trial is over, the court requests that both parties release their opening, closing statements on the case threads. Even though that would be appreciated, it's not necessary, as we can gather said statements from the videos in which the audience is recording.
That's fine, Ron, I can do that. Wahhfff, how would you like to be referred to as?
We will go with Wahhfff.
Wahhfff, okay. If I can direct the court to 40 seconds at defense, 38 seconds at defense exhibit 1.
Who was opening and closing trapdoors? Huh. Well, MGL, that's your last that's your first and last warning not to disturb this code. Pico, that also applies to you. Please avoid doing that.
37 seconds. And if you could just play that until 43 seconds, and I'll ask my question.
Gonna keep quiet.
The defense says
How are you so small?
the microphone does not work, and then due to that fact they are unable to represent their clients. The court would like to let them know of the possibility of using the in-game chat for that. I will also mention that because to the public outside to please remain quiet as to I do not ignore any statements accidentally. If I did ignore any statements, I apologize for that, and they may be reset at this moment as the timer for the witness has been paused. Uh,
And if I may also add, I believe Jaren's PC has crashed.
Jared's PC has crashed. That's once again fine. We believe he will rejoin soon, and we may continue. I also.
Hi, I'm here now. If you guys want to start, Minecraft's pulling up, but I have the audio being recorded.
Defense. The court apologizes for possibly having ignored any statements made by you. If that has happened, please inform this court and tell the court its statements once again so the court can review them. The second share probably development lines. Does the defendants concur to a second share? Second share. Can you take a look at this? Give me a second. If there are any other counsels to be added, please post proof of representation within the court thread so the court can properly allow the parties into the Google Meet and into the bench. Yes, it would suffice. Yes. Um. Defendants, Jaren and Wahhfff, do you concur to have MGL as another one of your counsels?
Yes, we do.
All right. Please. Take a seat. I'll send you the Google Meet link. Give me a second. There were small. Send this to you. Give me a second. I'll DM you the link. What's your Discord? Look at this. What's your Discord? Okay. Um. send you a DM with the case link. No. Give me a second. Some small technical issues. I have sent you the Google Meet link. Please do not share this link with anybody to avoid doxing. Please inform the court when you have joined. Let me also give me a second. Let me add another bench here.
All right, am I able to be heard?
You may. You may.
All right, good. I would like to request. Oh, I'm hearing an echo. There, that should resolve it. So I'd like to request a full to have Jaren reappear on the stand so we can have a recross examination. I never got a chance to examine the witness.
You may. You may. We will have 10 minutes for that. The 10 minutes will begin right now. You may begin.
All right. So, Mr. Jaren, would you please state for the record your experience playing on the server from the beginning when you first joined?
Objection, Your Honor. Objection, Your Honor. Relevance, and that's going to be such a
relevance
long
to state of mind.
answer.
State of mind of my client of how his experience has been on the server, talking to a stranger.
Your Honor, I ask that this answer be, Your Honor, motion to reconsider. I simply ask that this answer be condensed heavily. Because
I can do that.
Okay, that's fine then.
I can start with the we started working for fishing, and this is about maybe a day period, like an IRA day period. After we had done fishing, we had gone home, Wahhfff and I, to our apartments that we had just gotten, and waiting for us there was a judge who started to shoot at us. We then drove away, and then when we came back to our apartment afterwards, a player came into our apartment and just completely shot me. And later I found out that player was a judge. So I guess I would say, as who I am, I have been very much treated differently on this server. And because of that, people have been targeting.
How many times have you been murdered, would you say?
Like multiple times in the city. I would say there was one time we were shot at the dock, just in the back of the head. And then there was another time, I think then after that was the judge. Then someone RPG'd my entire apartment. I tried to call for help, yet nobody responded to that call.
So would you say that reasonably when you meet a new player, your first thought is that they're more likely than not to kill you?
Yes, I'm very aware that like they likely know who I am and would like to do something that would get them in the video.
That's perfectly understandable.
And killing them is that.
Would you say that you're more often than not a law-abiding citizen?
Yes.
So would you say that you've never intended to ever break any laws?
No.
So,
Your Honor, objection. Give me a moment.
What's the objection based on?
Perjury.
Perjury.
Your Honor, the witness has committed multiple offenses, specifically murder.
Defendant
Is
may
that
respond.
I would like to make an objection that that wasn't presented in evidence.
Can present the evidence in the objection.
A second. Uh, we will be overruling this objection as the court cannot locate any evidence in question to the accusation made by the plaintiff to the defendant in the case of perjury.
Your Honor, motion to reconsider. With an objection to perjury, I have to prove that the witness has perjured himself. I can't do that unless I present new evidence.
The response from the defense is that he's had his chance to present that kind of evidence, and that would surely have been relevant to the case if the plaintiff would have presented such evidence earlier. Then why is he doing so now at this time?
Your Honor, that's nice and all, but I'm going to object to that. That is a response to a. You know what? Never mind.
My apologies. I'm relatively new. I'm still a solicitor.
No. It's fine. Disregard the whole thing. Continue. I don't want to waste this court's time. I don't want to waste the court's time. You can continue.
The objection is withdrawn in this case.
Where was I? The abiding citizen. Shoot.
I believe, paraphrase, you asked, most likely than not, you are a law-abiding citizen, to which Jaron answered. I answered.
Oh, when you became when you first became an armor, what did you believe that position entailed?
I believe that position entailed just letting you craft guns so you could use them.
So so you're saying to the court that it was your understanding that the armor inherently had a firearms license?
Yes. Well, we had never been told that we needed a firearms license to craft said firearms license in the university exam or page.
So the last thing is, are you aware that were you ever made aware that a player that is in a smaller form has less hearts?
No, and we believe
you're on an objection asked and answered. This has already been asked.
My apologies. The question's withdrawn.
Yes, sustained in this case. You may continue.
I think I got everything I need to say. What is your relationship with your co-defendant Wahhfff?
We are real life friends, and I bring him on to make videos with me.
So in your statement previously played on the record, the quote, it's called intimidation, that was directed both at, you would say, at the audience and to Wahhfff?
Yes, I would say to Wahhfff. Hopefully, so he'd laugh a little.
And did the co-defendant laugh?
I'm unaware if he did. He laughs at most of my stuff, though. Shout out Wahhfff.
So my final question to you before I do this is that your primary purpose is to entertain and to enjoy the game. Is that correct?
Yes, Your Honor.
All right, no further questions.
Thank
Your
you.
Honor, Your Honor, I'd like to re-examine Jaron. I have a couple questions. Just a couple.
Gosh.
This shouldn't take
Back
too
to
long.
the stand.
Never getting out of this.
You may.
There we go.
Go ahead.
All right. Oh, sorry. Someone else speaking.
No. You may continue.
Oh, okay. Jaron, you've just testified that on joining the server, you have been repeatedly targeted and killed. Is that correct?
Yes.
When you approached the plaintiff, did he have a weapon equipped?
We were, as we were approaching, we were going to see, and but when we got there, no, there was no weapon equipped.
Was the plaintiff doing anything besides being seated and having just thrown one piece of fluff?
Yeah, you had thrown drugs at us, but that was about it.
So I'd just thrown one piece of fluff. Sorry, two pieces of fluff at both of you.
Asked and answered. The objection, Your Honor.
Go ahead.
I'm going to withdraw the
Objection,
question.
asked and answered.
I'm going to withdraw the question. So would you say that the plaintiff's behavior is similar to the behavior of the people you've encountered who have murdered you?
I would say anyone who has approached me, they just have approached me because we were public on the map. People would just approach, they would get close to us, and then they would attack.
Did the plaintiff approach you?
He approached the dock we were on, yes.
But did he approach you personally? Did he walk up to your person?
Objection, asked and answered.
No, I think this is a.
Well, you gave us items,
so
I would assume you are trying to get our attention, which I would assume is approaching us.
Okay. That's it. No other questions.
You have no further questions.
Nope. Oh, no.
In this case, following the timeline provided, we shall now once again, after there's a small misunderstanding which has happened, Wahhfff may now go to the stand, and the plaintiff may question the witness.
All right,
Hello.
I am ready.
Hello.
Mhm.
Matthew, were you able to play the Defense Exhibit 01 at the specific time? Yes, please. If you could play it from 37 seconds to 42 seconds.
Gonna keep quiet. How are you so small?
Okay. Wahhfff, can you confirm that you equipped your minigun and looked at the plaintiff?
Yes.
You claim in your defense that this was, 1 second, if I can get it.
Objection, that's leading question.
Does the defendant?
I haven't even asked the question. I haven't even asked the question yet.
No, the previous question with asking him if he equipped his minigun. If that
I said, can you confirm that you equipped your minigun?
was that present in the video?
Do you have access to the video?
No, I do not.
I suggest you either watch the stream on Discord or look at the case thread. It's Defense Exhibit 01. This is the main piece of evidence. You might want to bring it up.
All right. Objection withdrawn.
Go ahead.
Okay. It is stated in your defense that you momentarily took out your minigun for approximately 3 seconds before putting it away. Clearly not an act intending threat. Is this correct?
I did not intend to shoot you.
You did not intend to shoot me. Okay, well, jumping the gun a bit there. But it also states that more than likely, a simple coincidence while scrolling through your inventory. Is that correct?
Yes.
Can you state whether you had the minigun in your hotbar or not?
I did not have it in my hotbar.
You didn't have it in your hotbar?
I don't have my recording, so I cannot confirm it.
Objection asked and answered. Plaintiff
may
asked if it was in the
respond.
hotbar. The defendant has answered that it was not in the hotbar.
You may respond.
It wasn't in the hotbar. That's fine. I'm just going to move on.
No, I did not. I don't think I had it in my. No, it wasn't my hotbar because you can see me scroll through the items. Come to think of it, in the evidence, so that
So
wouldn't
just
make
to be
sense. For
clear-
the inventory.
So just to be clear, it wasn't. You're saying it was in your hotbar. Just to be clear.
I cannot confirm it because I do not have my recording, but in the evidence presented, you can see I cycle through the items.
That's fine. In general, do you keep weapons in your hotbar?
No.
You don't.
I don't even have a sword. Yeah.
But you have a minigun.
I did have the minigun for that. This was just after we crafted it.
Okay. Can you explain why you crafted a minigun and not anything else?
We crafted a minigun because we were the Department of Defense for a wild town. We chose the minigun because it looked the coolest. We did not realize it was one of the weakest guns, but
Just going to touch on that role. Department of Defense for a wild town. Okay. Is it a requirement to have a firearm?
it was required because we were the Department of Defense in
Okay,
charge of
and-
defending the factory.
Okay. And can you confirm whether or not you had a firearms license at the time you had this? At the time you crafted the minigun, did you have a firearms license?
At that moment, we did not receive the licenses.
You did not receive the licenses.
Yes.
So are you saying you filed to obtain a firearms license? Is that what you're saying?
No.
So you did not have a. So you didn't. Okay, no, that's
We
fine.
did not know the licenses were a thing.
You
But
didn't know
when
the
we-
licenses were a
upon
thing.
learning, we did apply, and we have
Okay.
since we have the licenses.
Okay. Have you been convicted of a crime relevant to this case?
No.
Are you sure? Have you been
That's
convicted of a crime
objection.
relevant?
I'm
Ask the answer.
Objection may be responded to.
Objection withdrawn. The defense, the witness has already answered.
I just want to make sure. Yes or no? Have you been convicted of a crime related to this? I just want to make sure I'm understanding you correctly. Have you been convicted of a crime relevant to this case?
No, I have not been convicted of a crime
Objection, perjury,
relevant
Your
to
Honor.
this case.
Objection, Your Honor. The witness is committing perjury. He has been convicted of unauthorized firearm possession.
Well, the crime itself. Well, I mean, other crimes, the ones that there's no extra things I was trapped up with.
Wait. I would like to chance to respond to that. Where is that been presented in record that the witness has been convicted of perjury?
No, I'm not saying that. Sorry, I'm not saying the victim has been convicted of perjury. I'm objecting on the basis that Wahhfff is lying when he says he has not been convicted of a crime relevant to this case. He has, in fact, been convicted of a crime relevant to this case, the exact crime being unauthorized firearm possession.
My response is what exhibit are you referencing that includes that as evidence that Wahhfff has been convicted of unauthorized possession of a firearm?
There is no specific exhibit relevant to that, but I can present this so that the objection perjury can be enacted. This is how it works. I can present this evidence that the witness has lied. This is that you can present new evidence in an objection.
Okay, so where is the evidence that he has been convicted of unauthorized possession of a firearm?
Your Honor, where would you like me to post this evidence?
Please post it on the case thread on the forums.
Okay.
Reference it to an objection presented during
I
the
will
trial.
format it as an appropriate objection. Bear with me.
ToadKing is the king of formatting.
Meanwhile, while the plaintiff is working on submitting his objection, the court will enter a small recess so everybody can have the time to go back to the restroom and or go drink some water. It's good to have some breaks sometimes. Okay, so plaintiff, please inform this court when your objection has been posted.
That's all right. I'm making it short, so it will be posted momentarily.
Whoever is utilizing cosmetics to make everybody jump, please refrain from doing so. Jaren, let me let you in. Yeah, it seems like you got dropped out. Second.
Spoiler, what is this? P006. What are we doing? 7. Oh.
Oh, let me mute myself in the Google Meet.
Again?
Yeah, but like,
Your Honor, the objection has been filed. I'm going to go AFK for 2 minutes. So please bear with me. I will state when I've returned. So give me 2 minutes.
All right, court is in recess until plaintiff returns. We have 3 minutes to provide their statements on the objections.
I am back.
Jeb, please. Oh my. Jeb, please refrain from opening trapdoors and flying all over the place. Jeb, please. Jeb, please refrain from opening trapdoors. We are currently awaiting the plaintiff to return.
I've returned.
Please,
Sorry.
you have
I'm
returned,
back.
right?
Yeah.
Okay, so where were we again?
The outstanding perjury objection. It has been posted to the case thread.
The defendant's counsel may respond to that objection alongside the new evidence presented as P007. Defendant's counsel? Defendant's counsel, you may respond. If the defendant's counsel is attempting to say anything, we are not being able to hear it.
Your Honor, I would respectfully ask if the defendant doesn't have a response.
They apparently have a microphone issue. Which...
Oh, sorry, I didn't see that. Sorry.
No issues.
I would state in the alternative that you could reply in the local chat.
You may reply in the local chat. Yeah, that's an alternative. You are supposed to respond to the objection posted by the plaintiff on the case thread, including P7 yeah, case. Lead counsel, please respond to the objection. Capt, are you there? Does the defend? Okay, you're
Click the link. It's there. And if you scroll to the bottom, the perjury objection is
yeah, it's at the bottom. Post number 17.
Testing. Oh, is it working now?
Yeah, it's working now.
It's working. Yeah.
Okay, good. I guess that was just an issue with the permissions. I don't know. So if lead counsel's unable to respond, I shall review this myself. All right. The court should conduct against. This was not. Am I reading the right objection here?
It's the one at the bottom, the perjury objection.
It's post number 17.
Oh, there we go. Right. Yeah, I don't see our response is that any any crime committed to the case, the question inherently has a time aspect to it. Of was what it was asked in the past tense. Have you committed? The witness is clearly responding that that they hadn't been at the time of the incident, that they weren't sentenced to any crime committed to the case. So.
Well, in that case, allow me a minute to look over everything, and I'll give out a ruling.
Where's my
The court has come to a ruling. Given the evidence presented by the plaintiff on post number 17, objection perjury, alleging that the defendant knowingly gave false statements under oath as during a court of law as a witness, the court finds them to have committed perjury as the unauthorized firearm possession fine given has as the unauthorized firearm possession is relevant to the case. The witness Wahhfff shall be fined 20 penalty units for
motion to reconsider, Your Honor. The witness very clearly thought that the question was referencing at the time the incident took place, had they been convicted of any crime related to this case. At the time the case was committed, that they were not elected, that they had not committed any crimes related to this case. And any incidents that did take place, as shown in the evidence, is not strictly related to this case. While the nature of the crime may or may not be considered related, the crime itself is not the crime. It's not one that it was involved with the plaintiff.
Your Honor, if I could respond. Right.
No.
The evidence shows that the defendant Wahhfff pointed the minigun at plaintiff. After this event, the defendant was then subsequently arrested and charged with unauthorized firearm possession.
This was many days after. I was not arrested for this. I do not believe. I do not think I should be charged with perjury because I don't believe this is relevant.
Sorry, Wahhfff. I'm not asking you a question. Yes? I'm responding to defense counsel's motion to reconsider. So, as much as you have a nice voice, you can't respond to this. I'm trying to respond.
Hey, I'd like to object if the plaintiff is arguing I do not have a nice voice.
Right, I'm saying you do have a nice voice. Anyway, the defendant pointed a gun at the plaintiff. The defendant was then subsequently arrested and charged with unauthorized firearm possession. On the balance of probabilities, the actions of the defendant, as put forward in the case, with the image of the defendant pointing a gun at him, on the balance of probabilities, this is what the defendant was arrested for. So the crime committed was relevant to this case. The act of pointing the gun at ToadKing, at myself, and that's what they were arrested for. To have been asked the question, have you committed a crime relevant to this case, to then say no, that is false, because you were arrested and sentenced to unauthorized firearm possession. That's all I have to say on that.
So, given the question presented by the plaintiff, in which it is, quote unquote, have you committed a crime relevant to the case? The court notes that no time frame has been given by the plaintiff, and that no time frame could have been interpreted by said question. The court will also like to note that even though the crime was created later, the question presented by the plaintiff did not say before before the incident occurred, which in this case the court denies the motion to reconsider, and 20 penalty units shall remain.
Okay. If you bear with me one moment, I'll have to remember where we were. Okay.
Bailiff. Please charge Wahhfff with 20 with 20 penalty units. Okay, give me a second.
Matthew, are you still with us?
Yeah, that's correct. 20 penalty units.
Matthew, are you still with us? Okay. If you could progress Defense Exhibit 1 to 47 seconds. From 47 seconds to 52 seconds. Oh, sorry, 53 seconds. So from 42 to 53 seconds.
Notes to the bailiff, a post has been made.
Big gun for such a little guy. Oh, he saw me holding the minigun.
It's called intimidation.
Okay. Wahhfff, in this exhibit, in the evidence, the plaintiff had typed "big gun for such a little guy." You then repeated that sentence to the co-defendant. Is that correct?
Yes.
So you were the one who said it. Okay. You said this at 47 seconds. Why did you, upon immediately reading that out loud, did you re-equip your minigun and look at the plaintiff?
To continue with the bit?
Can you explain what the bit is?
The conversation that me and Jerem were having about the threatening, I suppose I would have held it again. Because you brought up the gun.
So I just want to note that the plaintiff stated "big gun for such a little guy." You then repeated that back. You then equipped your weapon. You were the first person to equip your weapon, looking at the plaintiff.
I went back to equip it because it was the subject of conversation.
The subject of the conversation. Did you interpret the plaintiff's message to be, "show me your gun"?
No, it wasn't a command to say that, no.
So how did you interpret the plaintiff's message?
Big gun for such a little guy? I think it sounded like the plaintiff was just having fun.
Okay. Was the statement a fact? Was it a big gun, and was the plaintiff a little guy?
It was a large gun, and the plaintiff was a little guy.
So you held a large gun on the video in front of the plaintiff. I mean, right there, you can see it. If you look at the frame.
I was not aiming at your hitbox.
You were not aiming at my hitbox.
Objection, Your Honor. We're going in circles here. This is repetitive and asked and answered. The plaintiff was a little guy and the gun was big.
Plaintiff may respond to the direction.
Yeah, that's true. I will move on from that subject.
In this case, the objection is sustained. Go ahead, continue. Um,
As has already been affirmed by Jaren, Jaren made a further statement. How about you support these bullets into your brain? How did you interpret that statement?
It was in the private conversation between me and Jaren, I interpreted it as adding to the joke because we did not shoot you.
I'm thankful you didn't shoot me. But you laughed. You laughed very loudly.
Yes, because it was a joke in a private conversation.
So you maintain that the two statements made by Jaren were jokes?
That he would shoot you, yeah, those were jokes because we didn't shoot you. The situation was de-escalated. Nothing came of it.
It's been stated by Jaren that upon joining the server, he has been repeatedly targeted by players. Can you say the same about yourself?
I have been less so targeted, caught in the crossfire, definitely. I have been killed by people trying to get Jaren's head.
So it was also affirmed by Jaren that he is your real life friend.
Yes.
So during these moments where Jaren was targeted, were you always with him?
Yes.
Have you always been in the proximity of Jaren throughout your time on the server?
No.
So there have been moments where you have separated, been apart, not been together.
Well, of course.
But would you say most likely than not, you've spent more time with Jaren than not?
Yes.
So during the times that Jaren's been targeted, have any of you...
The objection, asked and answered. This we are repeatedly establishing that they are friends and they hang out on the server.
This is a very specific question.
Can
This
I
is a
respond?
very specific question. During the time that Jaren's been targeted, have any of you fired back in defense of yourselves?
Self-defense, yes.
Objection made before is overruled.
Okay.
Please continue.
So would you say you'd jump to Jaren's defense if he was targeted?
Yes.
It was said that a judge had mostly targeted Jaren. Do you know who that was?
Objection relevance.
Go ahead.
I could withdraw that. It's not that important.
You may respond to the objection made.
No, I could withdraw that question. It's not that important.
All right. Does the plaintiff have any further questions?
Yeah, just bear with me.
Excuse me.
Now, you stated to Jaren that you'd seen the plaintiff earlier at, quote, Miss Watson's place. Is that correct?
I do not remember that.
So you don't remember seeing the plaintiff, or you don't remember saying that?
I don't remember either. If you could show when that is in evidence,
Okay.
it could be proven, but that seems like a smaller fact I wouldn't remember.
At 20 seconds in Defense Exhibit 1, you state, I'll just read this out and paraphrase. Wait a second. I saw them at Miss Watson's place.
I suppose I would have said that then, if that is in the video.
So you don't remember seeing the plaintiff at Miss Watson's place?
I don't remember much of Miss Watson's place. I don't see entirely how it's relevant to the crime.
So you're unsure whether this was the first time you'd seen the plaintiff. Is that correct?
Asked
Yes.
and answered. Okay, withdrawn.
Okay. So on your testimony, you're unsure if this was the first.
At this moment,
That's fine. When you saw the plaintiff sitting there, why did you approach him?
because you were
Objection leading the witness. It's
Go
not
ahead.
been it's not been established that the witness approached the plaintiff.
Your Honor,
You may respond.
evidence. It's in the evidence.
Can you cite the evidence?
Defense Exhibit 1. At 15 seconds, Wahhfff approached the plaintiff. That's
Appears to approach the plaintiff. Yes.
we were just fishing when ToadKing
uh,
arrived at the area.
Objection
I just went
is
closer.
objection is overruled. Please continue.
So sorry, I didn't get a clear answer. Why did you approach the plaintiff?
Oh, because we were fishing and we were shot earlier in the same spot. Players arriving. I see another player arrive. I should go and look at them.
You were shot in the same spot.
Yes, by other players. Jaren was shot.
Why wasn't this mentioned in your defense?
Jaren did mention this in his
No,
testimony.
I mean, in
but it
your
did not come up in
answer-
did not come up in that
your-
from our lawyer.
Right. Okay.
It was mentioned that we have been targeted by many players.
It was mentioned that you've been targeted by many players, but you've just said you were targeted at this same spot.
Yes, at this exact spot.
Okay.
Which I believe is further reason for us to be intimidated when we see any player arrive.
So you were intimidated by the plaintiff.
Yes.
So you see a small player
They were
sat and
throwing fluff.
throwing fluff, and you were intimidated by this player. Is that correct?
Yes.
If you were intimidated by this player, why did you approach him?
To see if you would do anything. Maybe I wanted to see if you were friendly. I see somebody come, I walk over to them.
So even though you just said the plaintiff you were intimidated by the plaintiff, you wanted to approach them.
I'm not going to start sprinting away. I'm a little suspicious. I'm scared. I want to see if you hold a gun or something.
Did you see the plaintiff holding a gun?
After we pointed our guns, the plaintiff held an RPG.
Objection assumes facts, not in evidence. Nowhere has that been provided in evidence.
Response from defense. Are you objecting to your own question?
No, I'm objecting to his answer that I held an RPG after this event.
It was in response to your question.
You said we can bring new evidence into objections. We do have this recorded. We could submit it.
You may. Do so in the case, Fred.
Yes.
Oh, I'm sorry. What footage are you looking for?
When ToadKing fired the RPG at the yacht.
That is in
So-
the lawsuit, but it was objected though.
This
okay.
evidence has been struck. This evidence no longer exists. You can forget about this evidence. It's not relevant to this trial.
All right.
So
But you asked a question that my client has
You did.
responded to based in that evidence. So you brought it back into the record.
That is my answer.
Yeah,
You
I-
specifically asked if you
I
held a
simply
gun.
asked. I simply asked. Well,
So yes, I would agree that this evidence was not allowed before because it was stricken for the record. But through your cross examination, you have re-brought this into the record, and now it is allowed. So you can't. It would not make sense for the judge to grant you a motion to strike from the record based on your own question. Like, you can't object to your own question. That's ridiculous.
two things, Your Honor. In fact, one thing. I'm just gonna withdraw the objection. Okay, I'm going to withdraw the objection. The defendants. The question was, did you see the plaintiff holding a gun? I'm paraphrasing. The defense's answer.
I'm not gonna lie to match whatever evidence is up there. I saw the plaintiff hold a gun.
That's fine. I'll accept that answer. However, I would note the objection to Defense Exhibit 04. The events that occurred afterwards are not privy to this case any longer. Well, we're just going to move on.
How can I'd like to object?
I'm just going to move on. I'm not going to waste time.
You're saying it's not privy to the case, but you're
on.
bringing it up.
Let's please not yell at each other. Let's move on.
Okay, fine.
Move on. Go ahead.
Did you see the defendant doing anything violent before you approached him?
Do you mean the plaintiff?
Sorry, yes. Did you see the plaintiff doing anything violent before you approached him?
Not specifically violent. We were being careful not to break laws. We did see you throwing an item that we knew were drugs.
Okay, but it was perfectly legal to throw these. It was fluff.
At the time, yes. Mm-hmm.
At the time.
Which was not known by us.
Has anyone else given you fluff? So sorry, let me rephrase this question. Prior to this event, has anyone beforehand given you fluff?
Yes, at Willow.
Okay.
And they specifically said that it was a drug when we asked them.
Okay. And did you accept it?
No, we threw it back.
You threw it back. Okay. So I just want to note at 32 seconds, this doesn't have to be played. At 32 seconds, after you had approached the plaintiff, he then dropped fluff to you. Do you accept that? I mean, that's in the evidence.
Yes.
Okay. So the plaintiff didn't drop fluff beforehand to you before you approached him.
No.
So, and you were aware that the plaintiff had dropped fluff to Jaron because you were speaking about it. That's
yes.
Correct, yeah. Right. Did you see Jaron throw it into the ocean?
Yes. I would need to look through the evidence. I do remember him throwing it into the ocean.
It's at 4 seconds in, but that's fine. So just to paint the picture, the defendant had thrown fluff to Jaron. Jaron had then thrown it into the ocean. You two then deliberately approached the plaintiff. And you're
Yes, I
saying
walked closer.
that you were intimidated by the plaintiff.
Yes.
Go ahead.
You just bear with me one moment. Now, I've asked Jaren these questions, but I have to ask you these questions. Were you aware that a smaller player has less hearts than the average player?
No.
And are you aware of how much damage a minigun does?
Yes. To a player wearing netherite, especially, it would be not very much.
So you've tested the firearm beforehand?
Afterhand.
So you've never fired so prior to these events, you'd never fired the minigun?
After we crafted it, we tested it.
So you have fired it. Okay. So you know how it works.
I know how it fires, yeah. You right click.
And you have a reasonable idea of the damage it can do. Obviously, to a person wearing full netherite armor.
Yes. Very little.
And were you aware of the armor that the plaintiff was wearing?
Yes.
Now, the video evidence doesn't provide your point of view. It only provides it from Jaren's point of view. From the video, from Jaren's POV, you are holding a minigun, and it is inches, centimeters away from the plaintiff's face. Is that correct?
Yes.
From how it looks from Jaren's point of view?
Yes.
Okay. You contend in the evidence that it's just
Plaintiff, plaintiff, I'd like to mention that the time for witness questioning, according to the timeline, has run out.
I humbly request 3 minutes for 3 questions. That's it.
I will be granting that.
Sorry, did you say you will be granting?
Yes, that's correct.
Okay, right. Okay. You state in the answer to complaint that it was just a quote.
Yeah.
Where has it gone? Where has it gone? I'm going to paraphrase here. You state in your defense that it was just a visual artifact and you weren't intending to point the firearm at the plaintiff. Is that correct?
Yes, that was stated in the defense.
Okay. And from your point of view, it didn't look like you were pointing the firearm at ToadKing.
Not at your hitbox.
Can you describe what it looked like when Jaren was pointing the firearm at the plaintiff? Can you describe where exactly it was pointed?
It was pointed towards him, slightly above, mostly show off the fact, the subject of the conversation, that the gun was bigger than you are.
So I just want to say it was pointed towards him. Is that correct?
Yes.
No other questions? That's it.
Well, I would like the witness to remain on the stand. I'd like to take my opportunity to cross-examine.
That's granted. Please remain on the stand. You will be having 10 minutes. No, you will have 10 minutes to cross-examination. Yes, that's true. Go ahead.
All right. Wahhfff, how should I address you? As how would you like to be addressed in court?
You're on answered. Let's just.
I don't think you asked that.
I did. I did at the start.
They, them is preferred, but I'm okay with any pronouns if that's
I
what you're
feel
asking.
you. LNB here.
Nice.
So, all right. So did you? So I would like to ask a question that the plaintiff has not asked. Did you feel like you were approaching the plaintiff on that fateful encounter that day?
I feel like we're talking a lot about approaching. We were at our fishing spot. He approached the fishing spot. We see him there. We go closer. I wouldn't say I approached.
I appreciate that answer. So as the plaintiff has repeatedly mentioned, he's a small little guy, and that means he has 4 hearts. But I would like ask you: do you know how players become small on the server?
I have no idea.
Yes. Yeah.
Oh,
Yeah,
Your Honor.
Does
Your
the
Honor.
plaintiff have
Your
something
Honor.
to say?
No, no.
Yes.
Objection perjury. Objection perjury. The defendant does know how to become small on the server.
Did you tell me?
It's in Defense Exhibit 1. It's right there in the evidence. That was the nature of the conversation.
You think I read the evidence?
As my clients have repeatedly proved, they know nothing of the law. They know nothing about how not to perjure themselves, and they know nothing about anything that's been written in this court case.
Your Honor, objection badgering. The defense's counsel is antagonizing his own witness. I would like him to refrain from disparaging or making any comments of that nature.
Question withdrawn. All right. So when you were approached by a small player, has that been the first small player that you've seen on the server?
Yes, this was the very first time. I was pretty curious how that worked.
When you would say that you were interested and you were unsure of the intent of this player who's approached you at your fishing spot that you usually hang out with?
Yes.
Interesting. Now, would you? So the plaintiff has argued that that you are not well known, but I would ask you: do you feel like you have been recognized while on the server?
I have been recognized specifically as Jaren's friend. Yes.
And has being Jaren's friend caused you to be attacked or any way threatened in any regards since playing on the server?
Yes.
How has that made you feel?
I have been living in fear, always having to hide myself on the map to hide my location, because I have had several players come to me, ask if they can kill me, try and kill me, get my head.
Does the defense have any further questions?
Just 1 second, Your Honor. So why did you decide to become an armorer?
Because we were in the Department of Defense for the Wild Federation of Marona, we wanted to become armorers so we could make guns so that we could properly defend our factory.
Would you say that you were very qualified for the role of Department of Defense, and in the sense that you were actively able to murder and kill?
Yes, specifically against mobs. We did not kill players until far after this incident.
So you would say that you were really good about fighting Minecraft, mobs and monsters, but when it came to other players, that you were having a more difficult time defending yourself?
Yeah.
Have you fought against any players in the wild?
Not at the time of the incident. We did try to stop an invasion on Marona's factory, but I did not do well. I died a lot.
So you would say that invasion was on the attacker side was successful, on your side not so lucky?
Yeah.
So in general, any player versus player matchup on the server, you would feel you have a inherent advantage?
Yes.
Would you say that contributed to your at the time of the incident taking place, you taking out your minigun because you wanted to ensure that you were able to protect yourself?
Yes, especially against a player with special commands, a crown, netherite.
And you would say even of the ability to become small in stature.
Yes.
Would you have a more difficult time hitting a player who is the small stature?
Much harder.
All right. I believe that I have no further questions, Your Honor. I'd like to thank the witness for their time.
Your Honor, I would like to re-examine the witness. If you just bear with me for...
Oh my gosh, we're having our bite at the apple.
Again?
You had 10 minutes and I had 3.
15 in total with the extra part.
Everyone is given the same amount of time. I'm not going to argue. Anyway, I'll just bear with me one moment.
ToadKing, how much time do you need to re-examine?
Oh, less than 5 minutes. Extremely less than 5 minutes. We've got like three, four questions. That's it.
In this case, you can go ahead.
Okay, but if you just bear with me for one moment.
If in that case, would I be able to redirect, Your Honor? Following this,
say again, please.
Would I be able to ask further questions after ToadKing asks his?
If necessary, I would allow it. Yes.
Your Honor, does the defense have any more questions for this witness?
I do. I'd be willing to ask them now if you want.
Then please take your time. I'm not gonna. If you want longer than 3 minutes, then just ask your questions. I'm not gonna.
The defense counsel is has some real life commitments that they're trying to attend to, so that's why.
Oh yeah.
So basically, have you ever seen ToadKing fire a gun?
I have seen ToadKing fire a gun after this whole thing took place. They fired an RPG.
Objection, Your Honor. Assumes factual evidence. This specific evidence was struck. Strike the answer.
You brought it back. You ask the question the same question I did.
You bring in evidence during an objection is something you said.
Your Honor, this evidence has been struck. There is no proof that the plaintiff has fired an RPG.
D4 has been struck. That is correct.
The defense would like to argue, not necessarily at this time, but for a motion to reconsider, we'd be able to present said evidence to the court.
The same evidence that was struck in D4.
Yes, in a motion to reconsider the objection.
Your Honor, I will object to that on the exact same basis for the reason I objected to it originally. Please let me finish. The actions of the plaintiff that occurred after this event have no relevance on this case. Therefore, the evidence was probably struck.
I'd like to respond that the plaintiff was allowed to question my client on crimes that were committed after this case had occurred. Then we would like to be able to defend ourselves using events that occurred after the incident. If my client is being put on trial here for crimes that are being committed after the incident, then we should be allowed to defend ourselves and hold the plaintiff to the same standards my clients are being held to.
You may do a motion to reconsider if you wish to.
Your
Honor, we will file that after the in-game session occurs. Thank you for your time, and I have no further questions.
Plaintiff, if you still wish to have your 5 minutes questioning the witness, you may do so now.
I do. I'm just unsure of the sequence of events that just happened. What has been decided?
The court will allow the defense to submit a motion to reconsider for exhibit D4 after the in-game session is fulfilled.
Okay, then I will appropriately reply once it's been posted. That's fine. We can just leave that. Okay.
However, for the time being, D4 is struck from the record.
Fair enough.
Wahhfff, you stated that you would have difficulty hitting a smaller player. Is that correct?
Yes, I have stated that.
Would you have difficulty shooting a smaller player who has been seated and is not moving?
It'd be harder than a big player.
So would you... One second. But if we look at the sequence of events where you were standing in relation to the plaintiff, would you have had any difficulty shooting him with the minigun?
I would have been able to shoot him at that point.
And to shoot him, you would have to have pointed the minigun at him, correct?
Yes, it was not pointed at the hitbox.
So would you say it was pointed in the general direction of the plaintiff?
Yeah.
Okay, no further questions, Your Honor.
In this case, as we cannot bring in Larry the Fisher to the court, as they are currently not present, we shall move on to the closing statement.
Your Honor, I would like to object. Breach of procedure. The witness, Larry the Fisher, has had 5 days' notice to make their attendance known. They have not replied to this case. They have not made any effort to inquire as to how they will be attending. Therefore, I request that Your Honor holds Larry the Fisher in contempt of court. Every 1 minute they do not show up to this case.
Defense would also like to agree with plaintiff here. Larry the Fisher has made a mockery of this courtroom and of justice.
Give me a couple minutes to figure out the situation. The court has come to a decision. The case that Larry the Fisher has done has not moved to inquire about the case or the job as a witness for the proceedings of this trial. The court finds that Larry the Fisher, as a non-playable character, or also known as an NPC, cannot be aware that they are being called as a witness, as they literally have no thinking capacity. Therefore, the objection to hold him, the motion to hold him in contempt, is denied.
Motion to reconsider, Your Honor. As established by case precedent, Commonwealth of Redmond v. Gregg, 2025, FCR 64, the NPC, known as Greg, was duly notified and made their attendance known in the case. Subsequently, their wife had even presented evidence. To state that they have no, as Your Honor puts it, thinking capacity it's a bit insulting, but it's also from federal court precedent incorrect. Your Honor, I ask that you do hold Larry the Fisher in contempt of court for this brazen act of abstaining from this courtroom.
The defense would also like to co-sign plaintiff's motion. It is a complete mockery of justice if any witness is allowed to ignore summons from this courtroom.
In this case, the District Court of Redmond issues a summons for Larry the Fisher to appear within the court within 5 minutes. if they are not able to appear within the District Court of Redmond, in 5 minutes, Larry the Fisher shall be held in contempt of court.
Your Honor, I don't. Sorry. As we're now waiting for Larry the Fisher, if his attendance is not made, I request that this court enter recess for 25 minutes so that everyone can have a break and that closing statements can be drafted. Just 25 minutes, if that's reasonable.
That would
Defense,
be reasonable.
defense would agree.
That would be reasonable, yes. Larry the Fisher has 4 minutes and 30 seconds to show up to the District Court of Redmond. Larry the Fisher has 4 minutes to show up. Oh boy. Larry the Fisher has 3 minutes, 30 seconds to show up. Larry has 3 minutes to show up. Larry has 2 minutes, 30 seconds to show up. Mr. Comet, do you have a proof of representation? Larry has 2 minutes to show up. Larry has 1 minute, 30 seconds to show up. Larry the Fisher has 1 minute to show up to the District Court of the Redmond. Larry the Fisher has 30 seconds. Larry the Fisher has failed to show up to the District Court of Commonwealth of Redmond. Per Criminal Code Act. Criminal Code Act. Give me a second. Criminal Code Act. Contempt of court. Larry the Fisher is subject to 5 penalty units for failing to show up.
What a travesty.
As previously outlined, we shall now have a recess of 25 minutes. Of 25 minutes for closing statements to be written and prepared by both counsel. And yeah, we will swift so do that. I thank you all for your presence. In 20, we will be back in 25 minutes. Court is now in recess. Thank you.
One moment, Your Honor, can I raise something? You're still there. Or is everyone gone? Down. Matthew, are you still there? Okay then. Wow, this is a 3-hour case. That's crazy. That is crazy. Damn, we should have just. Where is it? Just trial by combat. Like 3 minutes. 3 hours.
Your Honor, we're being threatened. We're being threatened.
Whoa, 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 whoa. That's not a threat. It's not a threat, okay? Pursuant to the Judicial Standards Act, Part 2, Section 7, Subsection 2, trial by combat. In the event that both the plaintiff and defendant agree to a trial by combat, they shall settle the case through in-game PvP. It's not a threat. I'm just saying, you probably should have just done that. You know. Still could do it. We still could do it.
I am back. We still have 13 minutes on recess.
Your Honor, I would like to formally motion for a trial by combat. Yeah. Pursuant to Judicial Standards Act, Part 2, Section 7, Subsection 2. Yeah.
Does the defense concur to trial by combat? Defense? It seems like the defense is AFK. We have to wait.
That's fine. I can wait.
Recess is still ongoing, I believe.
Say again, please.
Recess is still ongoing, I believe.
Recess is still ongoing. That's correct.
Recess is still ongoing. Yes. Would you the plaintiff motion for on trial by combat? Does the defense concur on trial by combat?
No, Your Honor, we would not like a trial by combat and
The
played out
defense does
already.
not concur to trial by combat. In this case, recess is still ongoing. We have 12 minutes and a few seconds left on recess to prepare for closing statements.
Would the plaintiff like to end recess early necessarily, or
No.
You may
wanted to
end
see if
recess
you,
early if both parties
Wait,
concur.
I might
Yes.
want some more time though.
Oh, okay.
Can we go down
yeah.
to 5 minutes? Is that okay?
Say again?
Can we go down to 5 minutes on recess?
Yeah, sure. Does the plaintiff concur?
How long is left?
11 minutes, 33 seconds.
You want it done quicker?
Yeah, but I just need like 5 minutes to figure out my closing statement.
You want longer?
No.
No, five
Shorter.
minutes from now. So 5
Oh.
minutes, 6 minutes less than we have.
Math ain't mathing today. Can we just keep the 11 minutes? I mean,
Yeah, sure. we can do
Sure.
that.
Do that.
If that's simpler. Yeah. We know he got a small body, but we didn't know he had a small brain.
oh, objection, Your Honor. That is an inflammatory remark. I would like that struck from the record.
Rescinded, sorry.
We are currently in recess. We will be hearing this objection when we come back.
Your Honor, I would
Oh
note that
my
the
gosh,
statement was withdrawn, but the
The
goal,
statement was drawn, yeah.
the goal. Wow.
My apologies, I'm a new attorney.
Give me a second. Someone offered me a gavel. Let me.
Oh,
Oh,
I got it.
is that bribery?
All right, in all seriousness, that's your card, by the way, ToadKing.
Nope. I don't want drugs. Nope.
Is that bribery?
Well, that would definitely be bribery, but all right, I'm gonna go. That was nice chatting with y'all. Thanks for the fun court case.
Thanks so much for coming.
Thank you.
We still have 10 minutes on recess. Um, I got a gavel. Thank you to Stanley, which gave me this gavel. We have 7 minutes left on recess. Please refrain from opening and closing trapdoors repeatedly. It is deeply annoying. Go ahead, bailiff. That is fine. Is there any other member of the Department of Homeland Security currently amongst us?
Your Honor, I can be bailiff. Oh,
I'm sorry, but who
I,
is that?
ToadKing, I can be bailiff.
You,
I'm a
you
member
have
of
a
the
conflict of
DHS.
interest, obviously.
It's a good point,
So,
actually. Yeah. You could overlook it. I would like to know I am still the Sergeant of Arms for the Senate, and I was very good at that job.
seems like the stenographer also left.
Oh. Is this still being live streamed?
Yes, it is. I checked it not
Wonderful.
long ago.
Nice.
By M10 FR with RazNews still being live streamed. We have exactly 5 minutes left in recess. Oof. The court has been notified that RazNews and its live streamers have to leave in about 10 minutes from now. And no, the court does not intend on coming to a verdict today. There will be a separate occasion where the verdict will be delivered. Um, we have 2 minutes left on recess. Have 30 seconds left on closing statements. On recess. And Larry the Fisher has blessed us with his appearance.
Your Honor, then I've asked that the witness be allowed to. I asked that I've asked that my witness could be questioned.
As you can say in the galley. Larry the Fisher has appeared. Recess is now over. Court is back in session. Everyone, please be seated. We will now, according to previous arrangements made with the recess and the closing statements, we shall begin with the plaintiff side's 15 minutes, their closing statements.
Your Honor, is Larry here?
He's in the galley, yes.
He is still a witness. He has still been summoned, and I have not been provided the opportunity to question him.
In that case, you may do so. Just give me a second. You may do so. Give me a second. It's 7. Larry is over there on the galley. Okay, so I will be giving the plaintiff 10 minutes to question the witness, Larry, as per procedure.
Your Honor, is Larry going to enter the witness stand?
I don't know. I seriously don't know.
Yes, Your Honor. Is Larry privy to the voice chat? Can he hear the words being spoken now?
I'm not sure. I'm not sure.
Right.
With statements with recess over, 10 minutes have started now on question the witness. Go ahead, plaintiff.
Sorry, I'm just going to question the witness.
Yes, he is, as you can see, right there.
Can the witness hear me, or am I typing these questions out in game?
You can type it out in chat. I'm not sure if he can hear you.
So, okay. Let's
Larry might be mute, that's true.
Larry might be mute. In what sense?
He is unable to speak.
He is unable to speak. Your Honor, I'd like to object to the witness Larry as non-responsive.
Does the defense would like response?
We do not.
The defense would not like response. The court will be overruling this objection. As what it seems like, the plaintiff has not asked any questions thus far.
Your Honor, the
Not
plaintiff
only
did
that,
ask- Your Honor, I did. If you scroll up in the chat.
you said, Mr. Larry, thank you for attending this call today. I have a few questions. That's all you said.
Your Honor, I'm going to, with your permission, I'd like to ask one more. I'd like to ask a question, and if an answer is not provided, I would like to dismiss the witness.
Go ahead.